I should introduce myself. My name is Harrison. I work at the DC Office of the Tenant Advocate as an attorney advisor, and I am hopeful that this presentation will be educational, informative, and fun, hopefully. Okay, this is how, he did not get into that. All right, I was told to start with security deposits. If everyone feels that this is totally redundant, but I'm guessing it's not. All right. A security deposit may not exceed 1 month's rent. It may be collected one time. Frequently, we hear cases where a tenant paid a security deposit, then a few years later the rent went up and the landlord, I suppose logically, asked them to top up the security deposit. That is illegal. The security deposit may be collected once. Now, the security deposit is communication must occur regarding the security deposit within 45 days after the termination of the tenancy. After 45 days, the landlord may either return the deposit plus interest if the tenancy was for a year or longer, everyone goes their separate ways, yippee, or provide a written notice that the security deposit is being used to defray legitimate expenses. If the landlord does that, they then have 30 days to refund any remaining balance plus interest after deducting and also providing an itemized list of deductions. So the simple answer, how long could it be legally before the tenant gets back any remaining security deposit? Up to 75 days. Beware, oh, sorry. Yes, oh, so because the landlord is supposed to provide an itemization, the tenant is allowed to dispute that, and there are two options for where you can file a suit. If it is for under $10,000, you can go to small claims court. If it's over $10,000, you can go to civil actions court. You can also file a tenant petition at the Office of Administrative Hearings for security deposits. Pros and cons to both are outside the scope of the presentation, but that is a question that we get frequently at our office, and any of us would be very happy to explain that to the best of our ability if you're contemplating disputing a security deposit that you don't feel was sufficiently returned. If the landlord completely ghosted, that actually does happen too often. Once is too often. Now, before going forward, we would like to point out the rolling security deposit. At our office, we not so affectionately refer to it as the daisy chain. That's a situation where you have a tenant who moves out. Rather than the landlord collecting and returning the security deposit, the tenant, the departing tenant, is supposed to get paid the security deposit from the incoming tenant. Sounds tricky? It's a bad idea. Do not do that. Not good. All right. Right now we have a mini quiz. Will wear and tear. He files a dispute to get back his security deposit. The landlord withheld it. Under what circumstances will a judge likely affirm a housing provider's decision to withhold will wear and tear's security deposit? So, scenario one, Will vacated 3 months before the expiration of her lease term without notice. Will the landlord be allowed to withhold? Yes? Who says yes? Anybody say no? Okay, you're correct. Oh, just a moment. Door's open. Okay. Second scenario. Will is moving out and leaves a light scuff on the wall. Will the landlord be allowed to withhold for that? No? Return. That, yes. Okay, here, we'll pause for a second. Oh, Okay, we have a question. The question is, you were asking the threshold for small claims? Oh, okay. In order to file a small claims case, the monetary damages can't be more than 10 grand. So if there was a $20,000 security deposit, it could go to civil actions court, civil actions branch. It could go, a tenant petition could be filed. Again, there are plenty of what ifs though, or as far as even if, or if you've got a choice, where's the best where to go? And that, all right. So anyway, so to reconvene, third scenario. 30 days after Will vacated, her housing provider mailed her an itemization of the cost to repair a hole that was left in the wall. Will the landlord be allowed to withhold or required to return? Oh, okay, hold on a second. All right, why do you say that? Okay, for the rest of the audience, we have a very wise disagreement with the answer to the third scenario. What is, oh. Yes. Now, something to keep in mind, the landlord can withhold for damage beyond wear and tear, but there are certain points where what the landlord is doing is trying to take advantage of the security deposit. It can be very case by case. Unfortunately, none of the presentations today can possibly address every single solitary permutation. If it could, I think a lot of us would be out of a job. But, all right, last scenario. Will threw a going away party and completely trashed the unit. Beer cans everywhere, walls scratched up. Her housing provider kept the security deposit but never mailed Will any notice. I'll admit this is a bit of a trick question. What is the answer? All right, but listen, so yes, on one hand, Will did cause damage, but read the last sentence. The housing provider kept the deposit and never mailed any notice. Yes. Return. Now, I did say it was a trick question. There is a caveat here. There is a rebuttable presumption that the deposit is being wrongfully withheld and must be returned. If Will files a suit, like after 75 days, saying that they never got anything, the landlord will probably be allowed to nonetheless present damage. There are other jurisdictions, not DC, that are much more strict about having to return the deposit, no questions asked. So it can be always know the law where you are. All right. Oh, yes, in the back, please. No, I argue that it should be withheld if the hole is for, see, there are holes, they're like little like nail marks, and then they're like gaping holes. Like, I think that the question contemplated like a sledgehammer hole as opposed to like just nailing a picture on the wall. Here's the thing, we're gonna be passing out evaluations at the end. Please, the only way that we know to improve these things is, in how we fine tune, is through your feedback. So please share that with us. All right. I will now move on to rental receipts. Did you address this in the last presentation? Okay. This is a law that unfortunately is not complied with as often as it should be. Unless the payment is made by personal check and the tenant does not owe any outstanding amount, the landlord must provide written receipts. We can talk about what the potential penalties are and how often they're enforced, but nonetheless, the landlord is required to provide a receipt, except for the scenario that we just discussed. The receipt is supposed to state, am I coming in clear in the back? Okay. The receipt must state the exact amount received, the date the monies were received, the purpose of the payment, and any outstanding balance. All right, we are now moving on to rent control. That is a very good question. The regulation was written, I think, maybe 60 years ago. There are still parts of the regulations that refer to telegraphic communication of rent increases. At the end of the day, I think people have to use their own judgment. I mean, I pay my rent with a credit card and I get an online receipt. Again, I'd like to say that for sure that we have a clear answer, but I think that commonsensically, the tenant does have a traceable way of showing that they paid. All right, no problem. Yes, Rob? Sure. Okay. The question that we have in the back is, what happens when a tenant is trying to pay their rent and the landlord says, I will not accept it? Rob, you might not like the answer that I have for that. Sometimes the landlord has a legally strategic reason for not accepting the rent, because if the landlord issued the tenant with a notice to correct or vacate, if they accept rent, a judge might view that as them saying the violation of the lease was cured. So now that being said, if someone is handing money to someone, you would think economically that they must have a pretty good reason if they're saying no. I would say have them talk to somebody, because honestly, I can't say that it's not that simple. I will say this, at the end of the day, if you are trying to pay rent and the landlord doesn't take it, don't spend the money. Please put it in a piggy bank if you don't have a bank account, because if you get taken to court for non-payment of rent, if you can go to the judge and say, hey, I have the money here, the judge, I don't think, is going to be too fond of the landlord who just outright stubbornly refused to take the money. You know, honestly, unfortunately, I don't need to tell everyone here, stupid isn't against the law. But anyway, yes, ma'am, over there. We had a question? Did you have a question? Okay. Uh-huh. Mm-hmm. What if the landlord refuses to cash it, though? I think that, yeah, but see, the problem is, no, I don't disagree with I'm sorry, we've got some crosstalk. The question dealt with, well, it's not really a question, it's a comment that some banks will mail a check to the landlord. All banks will mail a check. There is often a fee for doing that. It's online. Are you talking about online bill pay? Okay, that's what I have done before with a credit card. Now, fortunately, my landlord cashed the check. Now, I think at the end of the day, the question that we had was, what happens when you have a landlord who just outright refuses to cash the check? The answer is, it can really depend. For the sake of time, I am going to ask to move on to the next topic. Oh. All right, so just a show of hands, do you know if you live in a rent-controlled or an exempt unit? Okay. Are you not sure? No, I mean, for the others, are people not sure? Okay. All right. When it comes to rent control, by its own name, limits the amount and frequency of rent increases. In general, rent control applies to units that were located in buildings constructed prior to 1976, if they are owned by a business entity, i.e., for example, ABC 123 LLC, INC, LLP, anything that has little alphabet soup after its name. If the landlord owns 5 or more rental units in DC, if it is not subject to a federal or DC government subsidy. Now, there are 7 rent control exemptions. If the landlord has failed to properly register for an exemption, then rent control technically does apply. In practice, there are a lot of fine points to that. So again, I have to urge, if you're suspicious or if you're just wondering, we can hopefully try to help in that scenario. Yes, ma'am. Oh, we have a question? Yeah. Mm-hmm. Okay, excellent question. When a unit is subject to rent control, assuming that the landlord has a current business license, is up to date on all their registration fees, that the unit is in substantial compliance with the housing code, the rent can go up once a year by what is known as the increase of general applicability. That means that the landlord can otherwise raise the rent by the consumer price index figure plus 2%. That number changes every spring. It's assessed by the DC Rental Housing Commission. Now, if a tenant is 62 years of age or older or has a disability, they can be exempted from the plus 2%. And furthermore, effective a year ago, if the Social Security cost of living adjustment is lower, then they get to take the lesser of the Social Security cost of living adjustment, the consumer price index, but at the end of the day, in a rent-controlled unit, the general applicability increase for an elderly or tenant with a disability who is documented with the landlord, 5%. Of course, okay. It is capped if the tenant is 62 years of age or older and has a disability and they are on file with the rent administrator. If Methuselah himself lived in a building and didn't file with the rent administrator, he doesn't get to demand that the rent only go up by that amount. So if you qualify and you have filed, the annual applicability increase may not exceed the lesser of the Social Security cost of living adjustment, the consumer price index, or 5%. Last year, the cost of living adjustment was 0.3%, so that was an easy answer. This year, though, the consumer price index is lower than the cost of living adjustment. I do not believe that in recent years the 5% threshold has ever been breached because of inflation. But the bottom line is it can't go up by more than 5% in that scenario. Yes, ma'am. That is not the increase of general applicability. That is known as the vacancy increase. The current law allows a vacancy increase of anywhere between 10 and possibly 30%. I will tell you there may be pending legislation that is trying to rein that in, so do keep a watchful eye on that. Yes, did you have a follow-up? Oh, just a second, she was still, sure. Okay, again, I'm sorry if I wasn't clearer about this. I was talking about what is called the increase of general applicability. There are other bells and whistles and loopholes and ways to increase the rent or to surcharge it, and unfortunately, that gets into the permutations that we can't cover exhaustively today. Yes, there are other ways. Yes, Rob, you had a question. Okay. That is, I'm afraid that could be, getting into the fine points of that could again go off on a tangent, but the bottom line is, theoretically, if there is a substantially comparable unit in the building where the rent is much higher than the other unit that was just vacated, for example, there was a longtime tenant that is no longer there, the landlord can raise the rent by a minimum of 10%, and if they so choose, so long as there is a substantially comparable unit, they can raise the rent to match that other unit, but in no case can the rent on the vacant unit go up by more than 30% of its rent at the time of vacancy. Yeah, oh, that is only for rent control. Exempt means exempt. All right, yes. Yes. Okay. We just had a question up front. What happens if the landlord is not in compliance with the housing code? Now, there's a difference between what is written on paper and what happens in practice. In order to take the increase of general applicability, and frankly, I think virtually any increase, the landlord is supposed to warrant that the unit is in substantial compliance with the housing code. Unfortunately, that does not always happen. On a tenant petition, there is a box to check off that said where for a rent-controlled unit, the rent went up when the unit was not in substantial compliance with the housing code. So does that render it null and void? The answer is it could, but with a lot, our slogan this year is powerful tenants know their rights. A lot of this stuff does not happen by itself. You sometimes have to bring it to the attention of someone for it to happen. I think that your question is an excellent dovetail into the housing code section, which we're about to start now. Now, I'm sure Sean talked earlier about how there is an unwaivable warranty of habitability read into every residential lease in DC. Does that sound familiar for the people who are? Yes. There is read into every lease in DC an implied warranty of habitability. It is unwaivable. The landlord must, yeah, oh. I'm sorry. There is an implied promise in every lease that the unit is habitable. It can't, and that is automatic. It cannot be waived. If a tenant ever signed a lease that says, I consent to live in squalor, a court should not enforce that. It would be unwise to sign such a thing for other reasons, but regardless, no matter what the lease says, this is something that the law reads into every lease. The landlord must ensure that the rental unit and all common areas are safe and sanitary as of the first day of the tenancy. And as I just said, it is read into every lease and explicitly required by district regulations. The landlord must also maintain the unit and all common areas of the building in compliance with the housing code. And that is a requirement to be able to take a rent-controlled unit rent increase. I do see your question in the back. The Department of Consumer and Regulatory Affairs conducts housing code inspections. Their number is on the screen, 202-442-9557. Yes, question in the back. Yeah, you had your hand up. All good. Uh-huh. Okay, all right, so is this student housing or is it just an apartment building? Okay. Uh-huh. Okay, ma'am, I'm going to tell you this. I get what your question is. That is, excuse me, for the benefit of the audience, no. Someone just asked about a specific building where there are a lot of college students who reside with 800 units, and unfortunately the residents have to resort to ordering carry out from like Uber Eats because their appliances don't work. That is, I'm afraid, fact specific enough that we need to go through the presentation. You're certainly welcome to ask that question, though, later on. Yes, if you want to say the housing code police, sure, 202-442-9557. You're going to get a recording that says, thank you for calling DCRA, yada, yada. Just press the number 6. Yes. I know we go over a lot of alphabet soup. It's sometimes hard to remember everything. Oh, the answer is that unfortunately, I'm not in a position right now to address specific cases like in this situation and then what is supposed to happen. So the answer is I really can't answer your question right now. What I can tell you, though, is if a unit is whether or not it's under rent control, the landlord is supposed to comply with the housing code. If it is not in compliance with the housing code, there are possibilities of sanctions. So I would suggest that any person who lives in such a building report it. Okay. Okay, unfortunately, all right, so then unfortunately that is, the person in the back just asked, she did report it, or tenants have reported it, but they're still waiting turnaround time. Okay, it's going to take 2 weeks for an inspection to come out. Unfortunately, the process of getting housing code violations enforced is something that could be the subject of a whole other presentation. So the consequences, well, at the very least, a landlord can be fined for not being in compliance with the housing code. If it is rent controlled, the rent can be rolled back. If the landlord increased the rent when the unit wasn't in compliance with the housing code, and the tenants can be awarded a rent refund. They can also sue for breach of contract. When someone signs a rental contract, they bargain for a habitable unit. Clearly, they're not getting the benefit of what they bargained for if they're housing code violations. But again, what an individual tenant might expect, what are the best ways to pursue that is very fact specific. Now, no, but nonetheless, that's still a set of individuals. So I promise I'm not trying to ignore that. All right. No, of course, and that's what we're here for. All right. Now, in certain types of displacements, the tenant has the right to receive relocation assistance. For example, if the landlord has filed a petition to conduct substantial renovations or rehabilitations and it has been filed and approved, if there's going to be demolition, or if there is discontinuance of housing use. Currently, the relocation payments are frankly not huge, but nonetheless, if a tenant ever gets a notice from the landlord that they are going to have to vacate, please seek advice. All right. Now, another implied covenant, another implied term in a lease is quiet enjoyment. When you rent rental housing, it's your home. You're expecting not to be bothered. The landlord has to make reasonable efforts to address disturbances caused by other tenants in the building. The landlord is allowed to make necessary repairs, in fact, they are supposed to, but they may not unreasonably interfere with the tenant's quiet enjoyment. They're not supposed to come banging on the door at 3 o'clock in the morning to fix a leaky faucet. Unless the lease says otherwise, a landlord is supposed to give a tenant a 48-hour written notice to enter the unit in non-emergency situations. Yes. Yes. Oh, are you a tenant in that building? Okay, so here, so someone up front just asked about an overcrowding situation in her building. She lives in a one-bedroom, but she is aware that in another unit there might be 9 people. Is it a one-bedroom unit? Okay, that might run afoul of some zoning laws and some safety laws. That is something that is possibly enforceable by a zoning administrator in the city. Okay, so here's the thing. Sometimes people get understandably frustrated because they're trying to report something that DCRA can handle, but they're reporting it to the housing code inspection. If you're calling DCRA, you can call the switchboard and just ask to speak to the Office of the Zoning Administrator. All right. Furthermore, a landlord may not pressure a tenant to vacate the unit. For example, blast loud music at all hours, turn off their lights, try to flood them out. Also, I don't know if this was discussed during the application process, but a landlord may not discriminate against any tenant or prospective tenant who is in a protected class. Protected classes, there's a long list in DC which is much more extensive than federal law. And also, what could be a discriminatory act? Refusing to rent, renting on unfavorable terms, conditions, or privileges, creating a hostile living environment, refusing to make reasonable accommodations, to give a person an equal opportunity to use and enjoy the premises. All right, now, not a fun part. Evictions. A landlord may involuntarily terminate a tenancy for only one of 10 specific statutory reasons. The District of Columbia is what is known as a for-cause jurisdiction. That means that a landlord must not seek someone's eviction because they feel like it. So, probably the most common reason, non-payment of rent. A tenant violated an obligation of their tenancy, which the tenant failed to correct after notice. The tenant performed an illegal act. Now, the next the next ones on the list, these are unfortunately situations where the tenant often has no control over the matter on this. Yes, ma'am. Sure. Okay, all right, unfortunately, that is a very fact-specific scenario. I am going to say, even if there isn't a law violation, frequently leases do have clauses in general about not causing a disturbance. Sometimes the language is written very vaguely. Again, I would encourage you to seek specific advice. Are you represented by an attorney at this time in the matter? You can call our office. Okay, you can call our office. I will hand you a business card, yeah. Now, some of the other reasons for evictions are the landlord wants to use the unit for their own use and occupancy. They want to sell it to someone for their own use and occupancy. We'll talk a little more about that when we get to the opportunity to purchase. They want to renovate, demolish, substantially rehabilitate. In some of these, for example, the rehabilitation or renovation, the tenant is supposed to be given the right to return. And also the landlord wants to go out of business or wants to convert into a condominium. Technically, for most notices to vacate, if they are not for non-payment of rent, a copy is supposed to be served on the rent administrator. Oh. Very unique part of DC law, a tenant may not be evicted just because the initial lease term expires, non-payment of late fees, or because the rental property has been foreclosed upon. Now, no matter what the reason, a landlord must go through the judicial process. That includes providing a notice to vacate if required, a cure period if applicable, and an opportunity to challenge the landlord's claims in court. Also, the eviction must have a court order and must be scheduled and supervised by the U.S. Marshal Service. Self-help evictions are not allowed, changing the locks, for example, shutting off the electricity. If a landlord attempts a self-help eviction, I'm serious, call the cops. If a tenant is being evicted due to non-payment of rent, they do have usually the right to avoid eviction by paying the full amount owed up until the time of the eviction. Up until the time of the eviction, that may also include court costs. And after an eviction writ is issued, the landlord may demand payment of the full amount owed plus court costs. No, well, let me explain. When a judgment for possession gets entered, the judgment is either redeemable or non-redeemable. When it's for non-payment of rent, the judgment, I say, is usually redeemable if there were other circumstances where the judge just decides that the tenant shouldn't be able to redeem the judgment. A specific example escapes me when it is just non-payment of rent. The tenant is supposed to be afforded the opportunity to pay back the rent. But for the landlord to redeem the tenancy, it has to be every last penny. If the tenant is even a cent short, they're not able to redeem the tenancy. Sure. No problem. The police wouldn't do anything. Oh, okay, all right, well. All right. I can't speak for the police. I mean, you are, depending on the time of day, you can go to court and seek an emergency order from the judge in chambers to order the landlord to restore access to the unit. That, unfortunately, the exact specifics of doing that are outside this presentation. Now, no problem. Yes, ma'am. And then, two questions, and then we do have to move on. Yes? Okay, someone just asked a question about someone who was evicted who had been, I believe, a ward of the state. That is, I really don't mean to be sidestepping, but I think a lot of the questions are very fact-specific, and that's really not something that we're able to accommodate at this time. Yes? Sure. Breach of lease is grounds to issue a notice to correct or vacate, to correct the violation. Oh. Two, it's the second one, violation of an obligation of tenancy. Yes. 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 Okay, we're being asked the question of if someone is in violation of their lease, is the landlord supposed to give them warning? Yes, the landlord is supposed to give a notice to correct or vacate. It's as simple as it sounds. The landlord is supposed to say, dear tenant, you have violated your lease by doing X, Y, Z, but you have X number of days, at least 30, to correct this problem, and you can do so in the following manner. All right, and then one last question, we do have to move on. Yes? Must. Okay, again, that can be, it depends on how far along a case has gone, if mediation is considered mandatory. In general, mediation is not a bad idea. If someone is being totally inobstinate about it, the judge probably isn't going, extremely stubborn about it. The question had to deal with if there was again, it really depends on the scenario. The question was, did the tenant must the tenant accept mediation? And the answer is it really depends, but frankly, as a general matter, I don't think mediation is a bad idea. But now, this part of the presentation is a relatively new addition to DC law. The eviction procedures were recently changed. Right now, the legislation is on, I believe, an emergency basis, which means the council does need to extend it. So all of this is subject to change. So up until recently, if someone got evicted, their belongings would be put right out on the street. That no longer happens. It's not supposed to happen. The marshals provide the tenant notice at least 14 days prior to the scheduled eviction date. The landlord is also supposed to provide notice. On the day of the scheduled eviction, the locks change. However, the tenant must, within 7 days after, be given time to remove the property. The tenant is to be given the opportunity to get their things out. If the landlord outright refuses to let the tenant in, that could be grounds to go to court. Because this is a very new law, this is frankly quite untested as far as what the simply put, if the landlord's refusing to let the tenant into the unit, in general, it might be worth going back to the court that issued the eviction order and ask for an order to allow them into the unit. Yes? Okay. Currently, the law is that the tenant must be given the right to get their things, period. Even if they haven't redeemed the tenancy, even if they owe a back balance of thousands of dollars. I do not believe that the landlord is allowed to refuse. If the landlord is saying no or imposing some condition like that, that is... Oh, okay. My understanding is that the landlord must let the tenant come in, no strings attached. Now, the landlord doesn't have to give the tenant a key. The landlord has to provide access for the tenant to remove their things, and cannot condition that on paying back rent, for example. But again, this is a very new law, so stay tuned. So, when did it start? I believe back in July or August. My understanding is that the U.S. Marshals no longer put people's things on the street now. Oh, okay, I'm sorry. There is another law that changed recently. Was the tenant opportunity? The question was asked about any new laws that passed in favor of landlords. It really depends on how you look at it, but that again is outside the scope of this. The Tenant Opportunity to Purchase Act was recently changed. We will get to that, and I do need to ask us to move on. So just a quick quiz. Gloria Good tenant has quietly rented her housing accommodation for years, pays her rent on time, and follows the rules of her lease. Nevertheless, the housing provider wants her out. Which of the following reasons could Gloria's housing provider legally cite? The lease will expire in 30 days and explicitly reads that the tenancy terminates at the end of the lease. Allowed? No. Good. The landlord wants to sell the housing accommodation. Is that grounds to evict the tenant in of itself? No. I will say this now. When we get to the Tenant Opportunity to Purchase Act, do understand whether or not a tenant has the right to purchase the unit, that does not mean that their tenancy terminates. All right. Gloria has a dog and her lease prohibits pets. The housing provider gave Gloria 30 days to get rid of the dog, and Gloria chose to keep it anyways. Can the landlord proceed with eviction? Yes. The housing provider wants to move herself into Gloria's unit. Is that allowed? Yes. The housing provider has found another tenant who is willing to pay much more rent than Gloria is able to pay. Allowed? No. However, the landlord, though, if it is lawful, can try to raise the rent, and unfortunately, if someone can't afford it, that may mean that they can't stay there. Yes? Okay. That is, again, a unique, the question is, someone was asking about number one, why a landlord can't evict a tenant just because, since their lease expired. Under DC law, leases never truly expire. The facial term might have run out, but by operation of law, the lease automatically goes month to month. A landlord cannot simply say to the tenant, you must move out because your lease expired. That just cannot be done. It is difficult because I think we might be the only jurisdiction that does this. I can't say for sure. I understand that that might not make the most sense to a lot of people. Sure. Yes. All right. Okay. All right, once again, that is the question that I was just asked is what happens if a landlord wants to move, says that they want to move into the rental unit, but really they just want the person out and they have other residences. A tenant is given the opportunity to go to court and say, I do not believe the landlord intends to move in for their personal use. Unfortunately, I have seen scenarios where a judge found that clearly the landlord was excited to get rid of the tenant, but the landlord does own the unit, and if they want to move back into the unit, they are allowed to do so. And it is not a defense in of itself that the landlord has other places that they could possibly move to. Oh, no, but if someone owns multiple homes, they're not necessarily required to stay in one place or another. Again, the issue could be very fact specific. If someone owns another house, that might be used to say, since they live somewhere else and you know that they have no intention of leaving it, that might be used on that. Now, moving on, a landlord, oh, sorry, one more question and then we do have to move on. Okay. Again, we can't cover every permutation here, but I will tell you, in the law that says in the section of the Rental Housing Act that allows the landlord to reoccupy for personal use, they're also not able to re-rent the unit for a year. If they do that, the tenant may have a claim for wrongful eviction. So, is that abused? Have people gotten away with not following that? Unfortunately, people get away with bad things all the time. Re-rent. Okay, selling it. That's once the place is vacant, it's vacant. But the landlord can't just re-rent it to someone else because, assuming that they reoccupied for their personal use. Right. Oh. All right. I want to parrot back your question if that's okay. All right, we've just been asked, so the landlord is not allowed to re-rent the unit for a year. Can they sell it? The answer is they can sell it. Now, obviously, if there are fact-specific scenarios where there was clearly just a ruse to get rid of the tenant, there may be possible action. Now, moving onwards, retaliation is not proper. The landlord retaliate against a tenant for exercising any tenancy right. For example, examples of protected tenancy rights. The landlord, the tenant says you need to fix the refrigerator. The tenant calls the Department of Consumer and Regulatory Affairs. They try to organize against a tenant association. Or my lease says that you're supposed to spray for bugs once a week and you're not doing that. Examples of what could be retaliation, simply trying to recover the rental unit just because the person exercised their tenancy rights. Unfortunately, especially in the case of personal use and occupancy, that's not always easy to prove. For example, another example of retaliation would be the tenant complained about housing code violations, so all of a sudden you start blaring loud music at 3 in the morning. That could be violating of other laws. Unfortunately, this is very fact-specific, so again, we can't cover every possible example of this. Now, sure, one question. Okay, the question that we've been asked is if someone makes a repair request, and the landlord says, we're on it, how long does it take? Unfortunately, I believe this was the subject of a report just released about a week ago. It's not always easy to determine what the period of time is to fix a housing code violation. It's easy for me to say a reasonable amount of time. Of course, what's reasonable to one person really might not be reasonable to another. Moving on. In DC, tenants have the right to organize. A landlord may not interfere with the right of tenants to organize a tenant association, convene meetings, and interfere with the right of the tenants to just talk about the building, just organize. All right. This is a section that we're not going to delve too much into. A landlord may not convert a rental unit into a co-op or a condominium unless a majority of eligible tenants vote for the conversion, and the city's conversion and sale administrator has to certify the election. And if a tenant is elderly or has a disability, they may have the right to continue to occupy if they meet certain low-income requirements, are age 62 or older, or have a disability as defined under the ADA. All right, this is something that I think many of you may have come here specifically about, the Tenant Opportunity to Purchase Act. This law was recently reformed in ways that I'm sure many people would say was not tenant-friendly. So as far as the question of any new laws that are landlord-friendly, this might be one. Before selling a multi-family rental accommodation, the landlord must offer the tenants the opportunity to purchase the accommodation. Now, not all transactions trigger the right to purchase. Common examples are, let's say 2 people get divorced and the court orders the wife to give it to the husband or the husband give it to the wife. There's a foreclosure. That would not trigger the Tenant Opportunity to Purchase Act. All right, right here we have a chart. It is in your booklet. It should also be available on our website that gets into, I just want to check ahead what the next slide is. Okay, this gets into specifically what happened. Does anyone here live in a single family unit? Okay, well, even not for the benefit of everyone, I will just explain how the law has been reformed. When it comes to a single family unit, which could mean a freestanding house, a condo unit, or perhaps a room that has a house that has an English basement attached to it, under the new law, if the landlord wants to sell, the landlord must send notice within 3 days of their intent to sell. The landlord can also send an offer of sale. Everyone is supposed to get this, and if the tenant is elderly or has a disability and signed their lease by March 31st, 2018, and moved in by April 15th, 2018, they may still have the right to purchase the unit. And there are, pardon? Okay. So, I think this is very self-explanatory. I know it's very new. Does anyone have any sorry? Oh. Well, no, all right, so that's probably one of the biggest changes. They can, all right, no, what they can do, for example, if a tenant doesn't qualify as elderly or disabled, they can go, or with a disability, they can go ahead and sell the house even if the tenant wants to have time to secure financing. Now, economically, it might make sense to sell to a tenant who is willing to buy. Unfortunately, sometimes many people don't behave in rational ways. One other change, a tenant can sometimes sell their TOPA right. Now, in the single-family context, if a tenant does have the TOPA right, the only compensation that they can get is 12 months without an increase in rent, whereas in the past they might have been able to sell it for more. All right. Sure. This chart, oh, I'm sorry, this chart is in the book. I'm not saying anything that isn't on here. Okay. The question is, if the seller wants to sell their property and the tenant is still in there, what is your question? No. What that is, if the tenant still, the question is, if the tenant is still in the unit, do they have maybe, could you repeat your question, ma'am? I'm sorry. Oh, if the tenant the question, I was just asked to repeat what I said before, and then we are almost done. If the tenant has the right to submit a statement of interest such that they can force the landlord into negotiations and not be able to sell to someone else in the meantime, that right can now only be sold in exchange for, let's say someone else buys the unit, that person agrees not to raise their rent for the next 12 months. That is the only consideration. Or for example, the owner themselves agrees that if the tenant doesn't get in the way of that the rent won't go up for the next 12 months. Well, it depends on what you mean by sell. The value on the market might not be very lucrative. But these changes are specifically to single-family units. If you live in an apartment building and it's not a condo unit, it's apartments owned by the same landlord, this law hasn't changed. The law has not changed on that note. I've been told that we only have a few minutes left, so I am going to have to just go straight through. If the person is a tenant and the landlord wants to sell the property, yes. Okay, no, that's what has changed. The tenant has to still be notified within 3 days, and if you read the law very strictly, the landlord is also supposed to the tenant is supposed to have 20 days during which they can declare themselves as being elderly or having a disability if they've met these criteria. So, yes, this is only for single-family units. This is very specific to single-family units. An individual condo unit, here's the thing, single-family unit is unfortunately, well, I'm not going to qualify, let me start over. A single-family unit can be a term of art. I think when people think of a single-family unit, they might think of just a freestanding house. The law, though, defines single-family unit as not just a house. Now, we're coming to, I'm afraid I can't take more questions. I have to get through this, I'm sorry. All right, this part is important. If moving out at the end of an initial lease term, send written notification to the landlord. Frequently people think that they can just leave at the end of the lease and not say anything. It is important to tell the landlord before you leave. If the lease does not give specific timing about that, provide at least 30 days notice. If the lease says that you have to provide, for example, 60 days notice, that may be allowed. There are specific words that need to be used. I'm afraid we do not have the time to discuss that right now. Now, during a month-to-month tenancy, the notification provided by law is 30 days. It's actually 30 days or a full calendar month, whichever is longer. It's not 30 days, for example, in the middle of the month. Now, before moving out, ask the landlord to do a walkthrough of the unit. A lot of security deposit disputes could have been avoided if the tenant has documentation of the condition of the unit. Don't forget to provide an address for the landlord for return of the deposit, All right, also, common sense, ensure the unit is in good condition. The landlord is allowed to retain the deposit for any damage beyond normal wear and tear. Clean the stove, clean out the refrigerator, have the unit look semi-decent, and broom clean at the very least, and remove trash and your personal belongings. All right, I'm afraid we don't have a huge amount of time for questions, but yes. Yes, so here's the thing. I'm sorry that I didn't say this earlier. I will hand out my card. Please feel free to call. Unfortunately, I can't promise that I'm able to answer immediately, but I can certainly try. All right. Yes. Okay, so we have a question about late fees. Ever since, I believe, the end of 2016, late fees, first of all, a lease must say that there are late fees. They don't just occur by operation of law. And the late fee may not exceed 5%. There are examples, I've seen leases where the late fee was 1% or a fixed dollar amount, and if that's less than 5%, that's a good deal, or someone may have lucked out. The city council passed a law that capped late fee, because before the law, you would see cases where late fees were 10% or even higher, and also, on our website, we do have a frequently asked questions sheet about the late fee laws. If you go to ota.dc.gov, we do have, I think, a fairly extensive question sheet. But again, I will hand out my card. And if I was not able to get to your question, or if I said that I couldn't answer it, please do not take this personally. We have a large group to accommodate, and also with a very fact-specific question, I'm a lawyer. Frankly, it's not appropriate to address someone's specific issue in a non-confidential setting. But anyway, okay, thank you.